So welcome back, and thank you so much, especially Martin, Jazine, and Pascal for this fantastic insights into the difficult and complex area of tax crimes, and also to our project experts for what they said. Now, what we will try to delve into is even more complex issues, but they are in a way what Olaf would like us to investigate when they ask us to look at the interconnections between tax crimes and corruption. So just as a very brief preamble, I can say that it emerged from 18 months research and all the activities that we have done, that basically looking at bribery as an only form of corruption, so direct bribes paid to tax officials to avoid taxation, is of course relevant and is a very, very marginal thing that happens, and especially in countries like the Netherlands and the North European countries where this form of bribes are not so common. Whereas the ways in which corrupt practices, even if not criminalized as such, actually, they affect the administration of justice in the area of taxation, are more pervasive, but also underestimated and understudied. So we will try to unveil a bit these kind of things. So we will start with two questions. Now, the first question is about direct effect on direct manipulation of investigations. The second one is less direct, indirect forms of undue influence. So let's start with the first one. So in the first one, basically, the first question is, what are basically the most prevalent practical means by which tax offenders or the intermediaries, so we've spoken about enablers or other intermediaries like financial institutions, are able to affect, influence, and manipulate and exploit the tax administration system. So this is more direct form of influence on specific cases rather than on the entire system. That will be, we will look at that in the second question. So the sub question is, according to your experience, which categories of professional enablers, for example, bankers, brokers, accountants, internal auditors, external auditors, tax lawyers, are most involved in facilitating tax crimes? So this is the first question.
Thanks. Trusts. This is where you have the offshore industry.
So when we speak about trust, so for trust, I think is the vehicle, is the legal instrument. So for the creation of these trusts that are something that is emerging also in other jurisdictions, for like the United Kingdom, what are the kind of professionals that they must be there to set up these trusts that are always there?
The trust industry as a whole. I mean, so it's every entity that is involved in setting up offshore corporate entities. It can be a trust, of course, that's the legal form as well, but I mean the whole trust industry at itself. If you look at Parmalat cases, if you look like the big case in the United States, there are always offshore entities involved where you store your money. You always follow the money.
Yeah, so to set up this trust, is this correct? We can say that we need a set of professionals, different like accountants and lawyers, for example. Are they involved?
Oh yeah.
Okay.
Any other lawyers, bankers?
Okay, so also bankers. That's the point of discussion we were looking. So bankers, lawyers, accountants. Any other you think professional? Any other form of professionals that are involved in other forms?
I think Pascal mentioning the trust industry in the Netherlands is a good point, because I think in several cases they seem to play a central role, and they point out to specific bankers, brokers, accountants, lawyers, tax lawyers. And when it comes to tax crimes, I think first and foremost, tax lawyers would be the one I would pick out of these categories.
Okay, yeah, that's a consistent actually with the other workshop we have in all the other jurisdictions, to tell you the truth. So let's say, so how often are these tax-related professionals that we are speaking about often subject to disciplinary measures, sanction, disqualifications, or even a prosecution for their, this at least unethical conducts, if we don't say that are illicit? Is common, is not common that they're debarred, for example, or what is your experience about that?
I see that happening. Oh, sorry,
Yeah.
Josien.
No, yeah, you can go first.
Yeah, I see that that happening. I think more and more, and that's something that we ask ourselves as prosecution office as well. And we can launch a full criminal investigation, but maybe we can also, or instead of that, file a complaint with the Association of Tax Lawyers, for example. Yeah.
And when you start the complaints, do you find the Association of Tax Lawyers, for example, responsive or effective in their actions? Or I understand that is an increasing trend. But
I would say yes.
Where are we now? Are we already at something that you consider satisfactory, or we are still in the unsatisfactory area?
Ooh. That I think it's hard to answer. Josien?
Yeah, I'm thinking, first of all, maybe to go back to the first question, something that I'm missing here a bit is, for example, the Chamber of Commerce. What you see many types of tax fraud is that there are these sort of fake companies, that you have these drug addicts or people without a place to live that all of a sudden own this company. I'm not saying that they're facilitating it, but there are maybe opportunities or possibilities to if they had more means to monitor this, you would make life more difficult in those types of crimes. For the second question, I actually, we go back maybe to a topic that we discussed earlier. I know that we've tried to prosecute some accountants, some big accountancy firms, not always with the best results for the prosecutor's office. And one thing that here is a problem here, that sometimes the legislation might not be sufficient. There are some articles, and this is getting very detailed, that are applicable to to commissioners or members of the board of directors, whereas could you then say that an accountant is an accomplice if he facilitated or if he was an active part of how they were solving it for the tax return? How do you say it? Like, it's
it's an issue of complicity and consultancy, and this gray area. This is very important, and we will look at this because I think you introduced the second question that will be more about how the system is created.
But I do have experience where you also have I'm thinking about what in Dutch we say the Autoriteit Financiële Markten. It's the authority that, how do you say, checks the
SEC equivalent.
Yeah.
So they check the stock exchange and also all the companies that are, so there you can also give information to them, and they can also file complaint to accountants or
like the SEC in the UK or the FCA, and but I can tell you that in the UK this is still in an unsatisfactory approach. So okay, that's very good. And one thing that I would like your comment about that is about the difficulties in tackling these things, and the capacity of these people to, in a way, manipulate certain types of cases rather than the entire system. We will see the entire system in your next question. How much is the contiguity, the professional contiguity, counts for you. I mean, this can be very important lawyers. This can be people in the big four, as you said. So their reputation is very high. Their knowledge is very, very technical. They have constant contacts with prosecutors, with tax authorities, with politicians. So this kind of contiguity, is this creating any problem, do you think, in this area of enabling?
Contiguity, yeah. How would we say that in Dutch? Josien, Pascal?
Yeah, I'm also thinking like it's a word I just don't know. Sorry.
The closeness, the closeness. How close?
Yeah.
I think it's getting further.
Because what I know, what I find complex sometimes as a prosecutor, and if you are a prosecutor for quite some time, as I am, we tend to be sort of perceive the world not black and white, but we're really like, they didn't interfere, they knew they didn't interfere, this is criminal. But we should always try to look at it from the perspective of other people as well. The role of an accountant is not the same as a prosecutor. So they have commercial interest as well, and they have the client interest as well. So I feel we have to take that into account. At the same time, there are definitely cases and investigations where they knew so much that you should always keep thinking as a national government, and we should give the input for that to the ministry. If this is what you think is acceptable for an accountant, for example, to avoid or ignore this or go along with this kind of behavior. So it's I think you have to continuously think about what kind of role you think an accountant or a bank, for example, should have. And this is, I think it's very complex, because of course, as a prosecutor, they have to tell us everything, and you have like more and more, especially like the anti-money laundering legislation and anti-terrorism, they have to come to us with more and more and quicker. But
so, Josine, if we're going to summarize, we have two competing issues. One is conflict of interest of these people, but at the same time, we have to balance the interest of what they do with the interest of justice. Okay, so business interest and the justice interest. So in these are, yeah, thank you very much. Pascal, you wanted to say something?
Yeah, well, it's a different angle with this topic. I've been into a couple of investigations where Big Four individuals and then top end Big Four individuals, they are quite close to administrative, like say a minister or something like that. And we have investigations where they used their good old friends, their good old boys network, to write a letter to the Dutch administrating office saying, hey, something is being investigated that should not be investigated, please drop it. That's also a problem that you get into when you work with people that are with this kind of backgrounds, that high level.
Yeah.
And it should not be a problem, but it is. And I'm not quite sure whether or not you can rule that out.
Pascal, this is a very important answer. Thank you so much, because you also mentioned one scheme that they can use. So undue pressures from the top. And in one phenomenon that emerged that is making this a problem is the so-called revolving door. So the passage of these people, for example, from business sector, Big Four, to the regulatory authorities on some ministries and so on, or more easily the opposite, from a very high position of public servant to them. And this is creating now this unfortunate situation where they can, if they want, put pressure. So is the phenomenon of revolving door happening, problematic in the Netherlands or not? Besides what you have already said, Pascal, of these cases that you follow, is something perceived? How much is happening? A bit of comment on revolving door.
Well,
I don't think that's the case. Oh.
No, please, Martin, go ahead.
I think it's a very interesting phenomenon. I don't think it's happening that much yet, but I wouldn't rule out that we are going to see that happen more often.
And Pascal, what do you?
Well, I wouldn't say it's something that's on a broad scale, because I haven't seen it too much, but I've seen a corporate income tax investigation that was blocked. I've seen insider trading violation that was hampered, and at least we were able to proceed. And we had some issues with financial institutes where we thought that they were doing something wrong, and then Ministry of Finance stepped in. So is that something that's absolutely wrong? That's something I can't really say, because at some point, as Yassine pointed out correctly, you have to look at the bigger picture. So
yeah, this is clear. And are there any measures in place to mitigate the risk of revolving door? So, for example, that after that you stop working for in a high position, you cannot just go and work for a business for a certain amount of years, incompatibility clauses. Is there something in place in the Netherlands to try to tackle this phenomenon?
good question.
Not that I know of. If I think for myself, I think I would be able to step down, say tomorrow, and start working as a tax lawyer at one of the big firms, for example. I don't think there's any rule that would prevent that.
Thank you very much. So following Josine comments, let's try to now look at the higher level, so the basic picture, why the system is like that, why there are, for example, no of these incompatibility clauses in place, stuff like that. So basically, what are the vulnerabilities, the institutional vulnerabilities of the system against these undue influences? For example, what do you think about lobbying? Because we know very well that all over, when we study tax evasion, and you were very clear when you said that the criminal law, criminal is very, very clear about what you have to do, but it's usually limited to blended fraudulent activities, like don't saying the truth in a tax return or forging a document. Whereas we have a lot of issues that are covered by and considered tax avoidance in a big gray area, very dark gray area, where we cannot prosecute because the system doesn't allow to do that well. And you said this emerged also from your panel. How much this is due to undue pressures of lobbying and other group of interests that they don't want to, that we tackle a lot? Tax avoidance in a way, and we want to limit this, because this is, I think, if we have to say to the European Commission, you have to look at the interconnections between tax crimes and corruption. I think this is something they have to look at, but it has to come also from you. So what do you think?
Well, I think if Martin and I and Pascal would have a good view on the lobbying going on, I think we're the last person they want to know about this. What I find is, because I've done several corruption investigations, which I find very complex anyway. But it's a very intriguing and interesting question. I think, when does something become corruption, and when is it lobbying, and where is the line? It's not always that black and white. And if you ask. I don't have like a concrete view of the lobbying. Do I suspect that's going on? Of course. I mean, I'm not that naive. So there will be lobbying, and I think it's also not a secret in the Netherlands, even though what I know, I merely know from the newspapers. I mean, we're called it like a tax paradise, and of course there are some big advantages for big firms to have at least a mailbox company here. And pay little taxes, and even though there are a lot of opposing sounds, I think it hasn't changed yet. I do think now, with the international, the agreement that's just been signed, I think the Netherlands signed it as well, to have like this minimum of tax that you ask from multinationals. But I have no doubt there is lobbying going on, and there's also benefits maybe for the national government. So yeah,
This is a very good question, Justine. I think that this is exactly the perception that very clearly expressed. And Martin and Pascal, any additional comment?
Yes, at this moment in the academic world of tax law, there's a heated debate going on about professors in tax law having a conflict of interests, and that there are in the Netherlands hardly any professors that are just a professor at tax law. Almost quite a lot of professors work part-time in the academia and the other days of the week at, in most cases, a big firm. And what seems to arise is this problem for the lawmaker and lawmakers if they want to, if they seek advice that is neutral and objective in the corner of the academia. The question is that, are they able to do that? Because the academia is
biased.
Well, yeah. Well, yeah, that's the
Exactly.
debate that's going on, and it's quite a heated debate, actually.
It's a very important debate, and this is important that you mentioned that. And with Joey, I think we will we face a sort of a reluctance of involving professors in this workshop, but then I think that one of the reasons will be what you said, and also I think there is also an issue, as you said, independent views. Being the big four, even at the European Commission level, one of the most important founder of research projects. So is this creating a potential conflict of interest where they should be the subject of the investigation, but they're also participating in this big project? I totally agree with you, and that's why we don't have the big four in our project, because I think this is an issue of independence of thinking. So thank you very much, Martin. And Justine, what do you want to add?
I wanted to add something, because I think it goes even further than if you need an advisor. And I know that in court cases, when we wanted to ask an expert about interpretation for a certain article, we ran into the same problem. But it's even further. I see that also in how do you say, like the fraud corner, is that if you look at scientific papers, there are much more articles, scientific articles by these professors / accountants or partners at big accounting firms, but also much more from lawyers specialized in fraud. Not fraud, committing fraud, of course, but you know what I mean. Because many of them are also like part-time professor, if you can say it like that, or lecture at universities, and we should reflect on that as a prosecutor's office. I think, like, maybe we should write more articles ourselves, but it's something that, because this influences also like governments and ministries and legislation. So this is a big ball that is rolling, I think.
This is fantastic observations, I think, and you are doing something. You're participating in this workshop as prosecutor, so you are doing something. This is an academic context. And Pascal, would you like to add something?
No, I was just thinking it all boils down to the same problem, whether or not we will say something about a tax lawyer that's something that has done something wrong to a bar, or doing. It's always, as the Dutch would say, you have a butcher testing the quality of his own meat. That's basically what you're boiling down to. It's the integrity of a person that's being tested, and there is no system that actually will make sure that it doesn't go to the wrong way.
And this is a very good point, Pascal, because in a international event that we done, we analyzed that there is a lack of independence of the bars when they have to decide of the responsibility of their members. So can you confirm that there is a sort of conflict of interest also, of course, in the Netherlands?
Yeah, there is.
Okay.
There is, and I've seen that in several cases. But the problem is there is this metal, and it's always shiny and gold on one side, it's a bit more dark on the other side. The flip side of the coin is you need the expert of that person in that industry to assess whether or not somebody has done something wrong. But that person then also has interests in that industry. So
Yeah, and as Josine said, the problem can be also perceived during the prosecution and the trials, because you need them as a witness, expert witness, and this is a very clear issue that we are experiencing all over Western Europe and in the United States, actually. So thank you so much. So I think project experts, any comment on this? Please feel free to intervene.
Yeah, I just wanted to make a point. I think we missed one thing when we were talking about who's culpable in the sort of offshore trust industry, and that's regulators, right? In these countries where offshore trusts are forming, it's not an insignificant revenue stream for those countries. But then I think we also have to think, well, these exist everywhere, right? So IP boxes in the Netherlands and Switzerland, offshore R&D activities in Ireland with Microsoft, and it's always easy for us to say, well, this is helping people dodge taxes, but then there are people in other countries blaming regulators or the government in our country for allowing other mechanisms that they see as stealing tax revenues from them. So I think, there's no easy direct solution of this, but there is this sort of, I think, regulatory competition among countries to create structures that attract businesses, and sometimes this essentially is globally a zero-sum game with tax revenues, right? So it's taking away tax revenues from other countries. And then I also kind of wanted to say there's also, I think, within countries, this sort of ties into some of the issues that made me think of there's this trade-off I think we see oftentimes between even the revolving door thing, and there's some cases of this providing best practices going back and forth, right? So regulators get people sometimes from the big four and now know what the newest schemes are, and then vice versa then, right? So when they poach somebody from the tax authorities, they get some insight into how the tax authorities are looking for things, right? And then I don't know if this is so much the case in smaller countries, but we look at big countries like the US, where there's this regulatory competition among agencies. And I guess you mentioned before in the UK, and sometimes overlapping jurisdictions or overlapping areas of enforcement, which can create some negative effects, turf wars and people trying to exploit loopholes and gaps. But the benefit is sometimes collaborations can arise, and if one agency isn't able to pursue it because of political pressure, sometimes there's an more independent agency that can. And then I guess the hope dream of the European project is some European agencies and cross-border agencies able to then, I guess, even fill in some of the failures of domestic regulators to sometimes close these gaps.
May I stop 1 second, you, Paul, because you covered very important things, and you covered the issue so important of regulatory capture, and I don't think that we have to ask the expert to go on, because it's very clear what you said, and
there's no answer, obviously.
Yeah,
right?
but
I just kind of wanted
I like
throw
a
that
lot
together.
what you said at the end. So the supranational check and how this can help us to solve the failures of the regulatory bodies at the national level. And I think that we have Dr. Vozza here, and Donato, are you here present? Do you hear me? Donato? Okay, Donato is not answering, but basically I know that he wanted to ask, especially Josine, on this supranational level, basically the role of EPPO, how EPPO can be added to OLAF to do this supranational check, and in a way try to avoid the regulatory capture that we can face more easily at the national level. And Josiane, we spoke about this, I think, when we said the threshold of interventions of EPPO. You said yes, but under this threshold there can be OLAF intervention. So can you just briefly comment on this?
Yeah, and then I mean, small disclaimer, because I'm not working for EPPO, of course, so I don't want to give the impression that I know everything about them. I work with them because I do all the cooperation between OLAF and EPPO, so I do have the experience that I've seen a lot of like the case material, what we've sent to EPPO to verify if they have competent like cases that were under OLAF. Yes, if you ask about the threshold, I do think like Olaf doesn't have a threshold. Even more, Olaf investigates irregularities, so we're not bound by the criminal intent, for example. So if you have a lower threshold, or if you don't have enough suspicion for a criminal offense, but there are allegations of irregularities, then Olaf has the competence to investigate that. And of course, as soon as we see that there is a suspicion of a criminal offense, we even have the obligation to report it to Apple. And if they are competent, they will take the case, and then we can have a parallel investigation, or they take over. It depends on the situation. And what I do see is that Olaf has, if you talk really about like the supranational, like the tax cases and custom cases, because I think they have a very transnational aspect. There is a lot of experience in Olaf. I can only speak for Olaf because, well, Apple just started. So if they have a lot of experience, they started in June, that would be interesting. But
speaking
so
about Olaf,
yeah.
Josine, in a previous workshop that we've done with Bulgaria, they said that they were a bit discouraged about the threshold of EPO because they thought that basically a lot of transnational tax evasion schemes will be under this threshold, and they are facing regulatory capture. So they wanted somebody to help them at the supranational level. So excluding EPO, the Olaf way, what will be what we can say to them, your colleagues in Bulgaria, how Olaf can help them, and what will be the consequences of your intervention?
Olaf is an administrative body, so if we investigate, and I say we, but I'm not an investigator anymore, they conduct an investigation, and at the end they write a final report with recommendations. So that can be financial recommendations. So they ask either the national tax authority or DG, for example, to ask back for the money that was owed. They can do administrative recommendations to even recommend that maybe the legislation should be looked upon again. They can ask for disciplinary measures, for example, blacklist certain companies, and they can make judicial recommendations. So either, and the judicial recommendation, that is if they don't report to Apple before. So if it's indeed under the threshold, or Apple has no competence because it's a member state that didn't join Apple, for example, then they can issue judicial recommendations to ask the national authority to start a criminal investigation. And what I've seen, I mean, I've had the pleasure of seeing some presentations from the units involved in these type of investigations. They're super professional, and they have a very broad network. So they work also, I mean, with different countries. So they, I think that's another good issue, that they can really bring together customs, prosecutors, investigators from different countries also in this investigation. And if they want to know how to report it, go to just the Olaf website. I mean, if you Google Olaf, the first thing you will see is the little snowman from Frozen. But if you Google Olaf Europe, I think you should get our website, and you can report any type of fraud. Anyone can report.
Thank you very much. Yeah, I always Google Olaf EU. Otherwise, there is there's no. Okay, having said that, thank you very much. It's a very good insight from a practical point of view of how we can use the supranational European check to, in a way, mitigate local national state capture. For the project expert, I abruptly interrupted Paul. Sorry for that. Any other expert would like to intervene on the issue that we covered so far?
That was the end of my point anyway. So
thank you, Paul. Thank you so much. Joe, Branislav. Nothing to add? Okay, so now breathing a bit, because we are covering a very complex issue now. These are quite easier now. It's something practical. institutional vulnerability in terms of powers. So now we have prosecutors and tax authorities here at this table. Do you think that in your jurisdiction you have sufficient powers in order to respond to tax crimes? And when we speak about powers, the use of instruments, intrusive techniques like phone tappings, also freezing powers. What do you think? Are your powers sufficient, barely sufficient, not sufficient, or you don't need anything else? Tax authorities, Pascal first, I think, because he's not speaking from a long time.
No, that's true. I was smiling because I think the powers that we have are quite sufficient. The problem is, everything evolves, the technique evolves, and there are just so many more means of communication that's encrypted that we can't reach, that we can't look at. So then we have the means to actually look at communication. We have the powers that the legislator gave to us to actually obtain that information. If we can't read it, if we can't access it, or they're using privileged persons to cloak the communications, we can't access it, and then we get into problems, all sorts of problems that we have then. So basically, in essence, we have the powers we need, but then in the practical way, can we always monitor the communication that we would like to get? No, that is a problem.
Okay, I will do like that. Let's finish with the tax authorities and then we go to prosecution. Okay, that's very clear to me. What about the legal instruments? For example, accessing to beneficial ownership register. You spoke about trust. I think this is the fundamental things are still in a nebulous area there. Access to transactions. When you speak, for example, with intermediaries, banks or financial institution, you can, it's easy for you to obtain what you want, examining documents. And also you speaking about following conversation. I don't think, but you have to tell me if you can use investigative techniques that are good for that. For example, phone tappings to discover corruption combined with tax evasion, or you cannot do that. This is the remit of prosecutors.
We can do that. We can do, for example, phone tapping. Yeah.
No, Martin, we're just focusing on our tax authorities right now. Then we'll go to prosecution.
Sorry, Martin. Now, if we have the powers to do phone taps, there's no problem there. So we can go to individuals, we can interview them, we can subpoena people to get information. We have the powers we need. That's not a problem. That's not a problem. Domestically, we have the means to go to banks or to trusts, and we can get what we need. The problem arises when lawyers are involved, because then it's privileged information that we can't obtain. And I think, unfortunately, maybe I have to say, there's getting a more level playing field. So we look at the Big Four and other professional enablers. They are getting more and more aware of how the criminal tax system works, the powers that we have as criminal investigators. And if I want to interview somebody to ascertain what happened, normally I would go there and people would answer more questions. Nowadays, people say, no, sorry, you have to go to the investigative judge and ask for a ruling to get me to make a statement. So it's getting more and more and more problematic to get the answers that we need, because people just know the system better.
That's very interesting. Penultimate question about resources. Resources in terms of personnel. Do you have enough members? AI is used, computing skills is there, trainings, but also vehicles, what you need. So do you think that the resources are enough, or you should need more of something?
Resources are not enough, but there is never enough, because there's always more fraud than we can handle. That is, unfortunately, a truth. You have to also maintain a balance. If we would go full-fledged on fraud investigation, we would slow down the economy. That would cost the economy in total more money than we would actually want. So
an issue of prioritization. You have to prioritize what to do with the resources that you have. That's the point. Okay.
So,
And yeah, anyone add something else, Pascal?
yeah, I would. In staff, we have sufficient staff. Do the people know what they need to know? No, not everybody, because computer techniques are getting more evolved, and we need to get more experts on that specific area. Getting across your message in a way that is understandable quickly is a problem. If we look at a newspaper, you get an infographic. I see a picture of the United States, I see red states, green states, Clinton versus Trump, and I know in one view, okay, what is the picture? Trump is leading the race for the presidency. That's something they can see from a picture directly. Those tools we would love to have, because then we would be able to, well, give a judge a good understanding of what's happening, and then that picture then of course needs to be substantiated with proof. If we were able to have tools like that, we could be much more quicker, and then we would, well, we'll be able to get evidence.
So it's an issue of training and of technical skills, and this is very important because also interconnects with what you report to prosecutors and how they can use them effectively in court. So very, very interesting. Thank you. The last thing, private-public discrepancy. Do you feel that sometimes big organization, private organization, like Big Four, they have a competence or instrument that are far superior of yours, and this can create an issue when you investigate? Or you think that in the Netherlands there is no so much distance?
No, there's a big distance. There's a huge distance, but it's not always a disadvantage. When I go to, if I go to the Visa, the credit card, and I would go to the systems and look at how they monitor transactions and things like that, that's way more evolved than what we have. So we can learn from that. And luckily, Visa is a company that will actually reply to our questions. So there is a big distance, and sometimes it helps us, and sometimes it slows us down. Just if there is on the right side of the thin fine line, then there's a company that's helping us. And if they're criminal, they will send you into the woods, as we would say.
Thank you very much, Pascal. Very good. Now let's switch to Martin, the prosecution. So Martin, and Josine, of course, the same kind of question. So we look at the powers. I mean, what powers do you have? We look at the issue of beneficial ownership and these legal tools, resources, and gap in resources with the private sector.
I think most of what Pascal said goes for us as well. I feel that I have, as a public prosecutor, sufficient powers, and we are always looking for personnel, for additional prosecutors. That's always a problem. A lot of people retiring in the Netherlands. One thing that Pascal also already mentioned, client attorney privilege can really extremely slow down investigations, and as I've learned, compared to, for example, United Kingdom and Germany, we have our system, our client attorney privilege is really, really strong, which surprises me if I compare that to these two countries. And one last thing, what was I going to say?
Resources?
Resources. Oh yeah, well, when you when you investigate a multinational firm, yeah, and when you talk about resources, that is sometimes a bit hard because they have an extremely wide infrastructure, digitally, with an archive, and it can be it's hard to investigate that because
for the amount of things that you have to do.
Amount.
Yeah.
Yeah.
At the citizen's office, I had to look at 20,000 emails from a bank in 6 months. I know that. Josiane, would you like to add something?
Yes, maybe a little explanation about the difference between the client privilege in the Netherlands and most other countries. Is that in the Netherlands it cannot be waived by the client.
Exactly.
Only the lawyer can say no, and then he's liable 99% of the time, so he will never do that. And this is a big difference. that causes a lot of trouble in the Netherlands, and especially since all these nice technological developments, because what is well, it was the trick already, I think 5-6 years ago, but I think it still is. If you're imaging some nice database of this really big multinational, which has like trucks full of papers, if you would compare to like visualize it, they say, well, there's confidential privileged information in there, there's communication. And then of course they didn't make a nice folder somewhere that says this is the communication with my lawyer. No, it can be everywhere, and then we cannot touch anything. And then if you look at resources, the field, so Pascal, and this is maybe also good to mention because I heard you say the tax authority, just to be very clear, Pascal is from the field, which is the criminal investigative body, like the Guardia di Finanza. So the National Tax Authority in the Netherlands, I don't think they can wiretap phones, not to my knowledge. So,
okay, so this is important. So this is because we have a specialized tax authority for tax fraud. So this is clear. This is very important, actually.
Yes.
And do you invest? How much do you investigate, both of you? I mean, prosecutions and specialized tax authorities, corruption cases and tax crimes together. I mean,
how many? Well, I wanted to.
Does it happen that you do investigate the corruption and tax crimes at the same time, or you do that separately? Usually,
I've had corruption investigations where there were also tax issues, but it was like there were several allegations in one big. In one company. I wanted to say one thing, if I may go back to the resources, because one of the problems is that maybe also prosecutors in the Netherlands have a lot of independence and autonomy and responsibilities, and much more than in most other countries. So a lot of what the investigative judge does in other countries, we can actually do. But one of the things that we cannot do is decide on the client privilege. There are many lawyers that say that even an investigative judge cannot even decide on that. But if a judge needs to check and verify if there's privileged information in like a database or in an image of a computer, they don't have these resources at their office in court. So this is, if you look at resources, this is a big problem.
Okay.
And this delays massively.
That's clear.
Yeah. And then you asked about, like, you wanted to know how many corruption or tax cases we have, or combined, or?
Yeah, I mean, that was a good, you already mentioned that sometimes there are multiple charges for one, against one person or one company that includes both of them. This is clear. What I wanted to know, if this happens often, or these are rare cases. And the second thing is, so both of you, both Prosecutor and Freud, you have the possibility to phone tap. Now, the problem is that we know very well that corruption is a kind of crime that needs this kind of intrusive techniques to be unveiled, because otherwise you will never understand it. So how often do you phone tap?
Well, I think
that's the issue. You can't do that. We know that you can't do that. Do you do that consistently? No, it's complicated, it's costly, it's resource.
No, I think the Netherlands is well known for wiretapping all the time. I mean, this is we're not just a tax haven, we're also a wiretapping haven. If you believe all the no, it's a bit of a joke, but we can ask an investigative judge to wiretap but we always do question if it's proportional, of course, but also if it's if we will get results. So do we wiretap a lot in criminal investigations? I think a lot less than in an average drugs or armed robbery investigation, for example. But we can do it.
And this is a very important, I think, issue, because this is happening everywhere. Even at the Serious Fraud Office, we didn't use phone tapping for corruption cases where we should have done, but maybe for organized crime, you do much more. And this is something happening everywhere, I think. Martin and Pascal, any other?
No, not so really. There's one thing I did want to add. In your previous question, you asked something about ultimate beneficial owner registers, whether or not we can access those or not. Domestically, that's not really an issue, because in the Netherlands, I can get everything I need. But when we go cross-border, and when they go to block traders and things, entities that are in a jurisdiction where they actually shield that information, then we get into trouble.
So it's not how the beneficial owners register is regulated in the Netherlands, or how is it regulated where the assets are transferred. We know this is a big issue, and yeah. So thank you.
May I say something about the wiretap? Because I think one of the things with corruption, yeah, because well, one of the things with corruption is, I mean, the cases that I had, maybe Martin has different experience, but very often we would have a suspicion of corruption that happened a couple of years ago. So unless you create some unrest, there's no use in wiretap, because why on earth would they start talking about corruption that they might have committed 5 years ago or 3 years ago? Unless there is a newspaper article or an audit or something going on.
Or
so
a judicial decision that says that they're innocent. So they say, well, I did it. I know, we know that very well. And you don't have to phone up only their phone number, but also the family phone number, all of them, because otherwise you will never get it. So we know this. Corruption is very, very, very insidious crime to be. Martin, would you like to add something?
One remark. Yeah, I think in my experience until now, I would say tax crime cases and corruption cases are usually split within our organization. Yeah, it can happen, like Josine described, that you add something to how do you say that, the indictment. In a corruption case, you add as well a tax crime, but I would say that's an exception.
Martin,
no.
And what I wanted to know is this, I think if there will be more investigated together, will be better to look at fiscal corruption for a clearer picture? What do you think?
It depends, I think. What I am thinking about is that in corruption, very often you have sometimes you have this shadow bookkeeping. So it's something that doesn't come in the official book. So that has an influence on the tax returns. Or another thing that you see is that they will put certain costs because they have to they paid money, so they have to put it somewhere in their bookkeeping, which is false because they paid it as bribes. So these kind of things, then it gets related to the tax return, which might be false because they put the cost somewhere where it shouldn't. But then you would go to like misleading or falsifying a document, which is which you might, but not really. I'm not sure if you would really add intentionally false tax returns, also because the whole goal, the incentive of doing it is different. Not to mislead the tax authority to not pay taxes.
No, but to disguise, the bribes. Yeah. That's why sometimes if you look at both of them together, you can look at different intentions. So that's the point. That's okay. Yeah. Thank you so much. Let's go on because we have to crack on with still 2 questions. So the one brief, please be very brief here. Just we want to know liability of legal entities. Is sufficient liability of legal entities against corruption and against tax crimes? Are they, this kind of, is this criminal liability, administrative liability, and what do we want to know is there any difference between tax crime liability and corruption liability in the way in which, you go against the corporations, or both in legal terms and in practical terms? Please.
I would say no. You wanted it briefly,
yeah,
right?
No, that's very good. Just a bit of context. No, there is no actual difference between anti-tax crime and anti-corruption strategies against corporations.
No, I think the same set of rules apply to decide whether or not a legal entity is liable, because that is possible under Dutch criminal law.
So it is criminal liability, full criminal liability?
Yeah.
Okay, good. And are there any alternatives, proceedings, alternative to criminal response that they can activate, like settlement resolution, negotiated settlements, deferred prosecution agreements, that they can, in a way, divert from ordinary justice in the Netherlands? Can they, when investigated, come to you and wanted to enter into an agreement, the legal entities, and they can settle these cases? Is it possible?
Yes.
In our I think the trend now is for a few years it has been in bigger investigations that we might settle with the entity, criminal settlement, and then further prosecute in an open court certain individuals. But
Because-
both would be possible. You could also settle with individuals and prosecute the legal entity in open court.
The only thing is you cannot imprison companies. That's a bit difficult. So
nobody to kick no sul to dam.
No, so you would ask for how do you say, like a fine or
what is important, I think what is important for the purposes of this question is now this settlement procedure. For example, in the United Kingdom, in the United States, we have studied it a lot, and we realize that sometimes the corporation knows that can settle this, so they can in a way plan to conduct this kind of criminal activities, tax evasion, and include this in business costs, because they know that they will negotiate with the prosecutors and pay a huge fine, but in reality for the corporation is not huge at all. So for certain types of corporations, of course, the big ones. So what do you think? Your point on this? As a prosecutor, is it effective? Do you think that sometimes is an easy way? Is this going away from justice? We need that, because otherwise there will be competitive disadvantages, as somebody said. I think Paul was mentioning that, of Dutch corporations. Your point of view?
I can speak from my own experience in processes of these settlements. I think it would be risky if companies would commit crimes with, like, worst case scenario, we would get a criminal settlement and we would never go to court, because there is a serious chance of going to court. And maybe I'm very idealistic, but I was under the pressure that the procedures where I did the settlement is, first of all, we would be with not one prosecutor. If it's a big case, would be with at least 2 prosecutors on the case, and then we would reflect with several people in the hierarchy, like the chief prosecutor, the deputy chief prosecutor, other people that are way more experienced. Every step of the way, we would make very clear from the start that the prosecutor's office has the director. That of course they have the opportunity to give their opinion, but it's not a, how do you say it, like it's not a negotiation. We present the facts that we see and how we have investigated them, and they can of course respond, and also if they have very good arguments, we have to seriously investigate them. And what I like to think, that as a prosecutor you really try to think, like, would there be enough evidence in court? Like, would there be a good chance that judges would convict this? Otherwise, you shouldn't. I mean, I'm also a magistrate, and I'm also objective, so I'm not there for the kill or anything. What I think is sometimes in the press not very highlighted, because there's a lot of negative press, like it is a negotiation and they get up very easily. Is my biggest goal as a prosecutor, but this is really personal. My biggest goal as a prosecutor is that whatever suspect thinks the next time, I'm not going to do it anymore. I don't want to do this. I want to do it a different way. And by involving them in this procedure, by having meetings, and it's not a negotiation, they have more, how do you say it, like I see quite often that they want to change. They want to change their compliance. And also you make appointments. Part of the agreement is that they have to change their compliance, and that is not possible in court, for example. So
no, that's clear, and that of course there are advantages of this settlement against, both for the prosecuting authorities and for the state itself, as you said, like mandatory compliance programs that you can impose that otherwise you cannot impose. Yeah, it's clear to me, and I think Joe maybe would like to interact on this, because in the area of corporate recidivism, unfortunately, it's emerging that they do not change. So I don't want to break your positive, but it's happening. They're not really changing, and that's an issue that difficult to face. But I understand your point of view. And Martin and Pascal, before I go to the project expert, yes, Martin, please.
Yes, I think it's a really interesting question that I ask myself. I don't know, every month, because it comes up in cases. And what triggered me was the book I already mentioned by Richard Collier, because he describes these behind closed doors settlements as maybe a privilege for certain parties. And I'm not sure whether or not the actual fine that you could impose in a settlement, or compared to a fine that would be how do you say that, given by a criminal judge, if that is one of the most important things, or is it the publicity and the fact that that the debate will take place in open courts? I would say that certain parties fear mainly that the fact that it's out in the open, and I doubt whether you should give that kind of privilege to these entities.
This is a very good observation. Yeah, the reputational damage of the court audience for them trial is the risk. It's not what they have to pay. Okay, project.
I do want to make one really important point, because behind closed doors is, and I'm not an advocate for settlements, because I don't fear taking them to court either. But in a settlement, in like these big cases, there has to be like a statement of facts and a very extensive press release. So it's like everything is there out in the open, like the statement of facts and the outcome. So it's of course it's different than
Josiane, may I ask you a question in that, because I think that here the issue will be access of NGOs and journalists to this. Besides what you use for the statement agreement, is all the investigation material that you use for entering into the settlement open to inspection or not?
No, the statement of facts will be.
That's the issue about transparency.
But I mean, I've had court cases where the judge would say, "Hi, we're all here. We all read the file. Shall we just start with the question?" Then I don't go through these 200 files of. So maybe it's also a bit naive to imagine that everything will be discussed in court.
Yeah, that's true. I totally agree. That's another a practical problem that is there. Okay, so project experts, please.
Well, we could say that it's a very important point about the transparency issue, because really all that matters is the press release. We can measure the damage reputationally. That's what Paul just put up on the earlier slide. And so looking at the cumulative fines of the particular companies and the propensity to essentially endure them is a rating that, in fact, credit and other parties will have in terms of the quality of the company. So if larger companies rely on institutional investor engagements, that is to say, they can have a view about limiting fraud as just like limiting, other kinds of wastes, that is to say, greenwashing and so forth. It may be that they'll be able to have some impact on companies by virtue of looking at the fine levels and the number of them over time. So this is the point that Paul made. And that's a technique. And that's why prosecutors, when they get settlements, we can actually see the effect, the market response, and the ultimate long-term reputation of these firms. So the market works closely, I think, with the information that you get. And you probably don't need to have a long court record on this. I remember when I was working in U.S. court and they had fines, really what mattered was the market response.
Thank you very much. So let's go on with the last something question, and then we have the conclusion. So the last question is about whistleblowing. So how much do you think is important to have whistleblowers in unveiling tax crimes and corrupt cases in taxation area? And how much do you think that whistleblowers are protected in the Netherlands, in the system? Enough, not enough? Are they rewarded? Should they be rewarded? Protection and rewards, a general discussion of, and also, their relevance in your investigation.
I'm not sure whether or not I had a case with a real whistleblower.
So they were more, you're saying that because for the fact that they were insider of the organization. So most likely you had informants that were not surely whistleblowers per se. Is that what you are?
Yeah, I think recent cases, the whistleblower was maybe an organization that actually complied with anti-money laundering rules and filed a SAR report, and by that blowed the whistle and formed the start of the criminal investigation. But yeah, whistleblowers in the real essence of the word, I don't have experience with that. I think no, in my cases.
No, me neither. No, it's I'm also thinking, like, I know we have this like whistleblower house, and I know that I think as in many countries, there are, of course, there are stories that I know from the newspaper where whistleblowers ended up living in a caravan, losing everything, things like that, which I think it's on European level. There is legislation now for whistleblowing. I mean, I've come across this here in Olaf. But indeed, me personally, no. We get a lot of information, I think, from via FIU, via the tax authority, different other cases, or indeed people. Maybe I'm even thinking like people. No, not really. Like I only know it from the newspaper. So sorry.
No. Yes, media are very important. So what the line inquiry here will be the fact that they are not so common. The fact that only once, for example, Martin experienced the presence of whistleblowers. What do you think is the reason? Is a cultural issue? They do not blow the whistle in the Netherlands for some reason. They feel not protected. Are they retaliated against? Because why? And in general, do you think that they could play an important role? Do you feel that they could play a fundamental role in helping you unveiling things that otherwise won't emerge? What do you think?
I think they could, but like Josine said, I think my understanding of being a whistleblower in the Netherlands and in Europe is also influenced strongly by newspapers. And if I would imagine that for myself, I don't think I would want to be a whistleblower, unfortunately, in the Netherlands, because although we have this house for protection of whistleblowers, indeed, you see them ending up living in a caravan. So I'm not sure whether or not the climate is very beneficial for potential whistleblowers.
I'm also, and I think it's actually, even if you would turn around the question, I think it's a very complex matter. If you wouldn't look specifically at whistleblowers, but if someone would speak up, maybe even internally, or indeed go, I mean, with a whistleblower, I think of someone copying, stealing USBs full of money, and it can be like smaller than that already. But very often you have a certain culture I think culture in companies is very important. Culture usually allows certain criminal offenses, for example, or irregularities. Very often you might have people who get well, or they benefit even with bonuses from this culture, or they like this culture. That's why they choose this this company. And I think also you have to really look and be experienced in psychology. A lot of people are afraid of change. They are afraid of consequences. They might rather, they are afraid to stir the pot. They might rather find a different job, or did they try maybe speaking to their boss, they didn't listen, they thought, okay, well, then I'm just going to focus on my own stuff. It's I think for Martin and me we couldn't provide a solid answer.
No, this is a solid answer, Josiane. You provided, both of you, a very solid answer actually, and it's very good. And I think that you cover all the points, but a bit, you also covering the unserving loyalty that is sometimes inside institutions, and fear of changes. Yeah, I think these are common things that we are experiencing all over Europe, and we will see what will be the effect of the whistleblowing directive when it will be implemented in all the countries, including the Netherlands. We don't know yet. We will see. So I think now let's end this fantastic discussion with the last question. It's an open question also for our project experts. So if you had a magic wand, and you can change one thing in the Netherlands and say, I want to fight corruption and tax evasion, and I can change this. Josiane, what will you change?
Now I have to start it. First of all, maybe say something. I traveled a lot to other countries for work, also as a prosecutor, but now also living in Brussels for a while. Let me first and foremost say that it gives you a new perspective, and things are going pretty well in the Netherlands. I think we have a really decent legal system, and we're very lucky with the field and with the police, and so we're very efficient and pragmatic. If I could change one thing, this is gonna be not a really it's gonna be a very idealistic. I would like people to take their own responsibility and realize why they are paying taxes. I mean, we shouldn't put all the responsibility, but also all the confidence or whatever in investigations. It should stop before that. People should have a more moral and ethical compass and think about what they're doing and why they are so greedy. So if I could change one thing, is people be better.
I think it's fantastic wish, the ethical dimension. Yeah, thank you. Thank you for this answer. Martin.
Yes, I think the first thing that comes to mind is the client attorney privilege. It is important. I worked as an attorney for a few years before I started as a prosecutor, so I understand the importance of being able to speak freely with your attorney, but in our cases, it is quite a hassle, to put it mildly. So if I could change one thing tomorrow, I think I would do that.
Thank you, Martin. And Joe.
All I have to say is, being an American, but having a second country, is I agree that the Netherlands is an incredibly well-organized and efficient legal system with top-class prosecutors, as we've heard today, as well as lawyers and intermediaries. The only thing I would hope for is more market mechanisms to deal with fraud, and more data for at least some people to analyze the incidents and the success in mitigating fraud and evasion. But that would be the only thing I'd want more of.
Thank you very much, Joe. Paul.
I'll borrow one from Joe. I think data is the most important thing. I think not just for researchers and academics to analyze things, which I think is also a big part of it, right? We only have data to look at the FinCEN SARS leaks because they were leaked, right? Usually this data is really closely held by the regulators. And I think that's the same across a lot of countries. And I think not having some kind of anonymized access to data makes it hard for us to really judge the effectiveness of different policies, and then for policymakers to really have an idea of how to improve those.
Fantastic. And we have finally Donato, just in time to use the magic wand.
Thank you very much, Costa. Many thanks. I have had the opportunity to enjoy a part of this discussion. And let me say that it is really fantastic. I'm not able, of course, to say what to change in the Netherlands, of course, but I'm sure that there is a lot of work to do together from an international and European perspective. I'm confident that time is coming to deal responsibly with corporate tax avoidance and tax evasion, especially from an international perspective. It may be that you, Costa, has already asked this question, but I think you have already talked about the role of a journalist in identifying and revealing illegal conducts. And I have a last question, if I may, also if I know that we are at the end. What impact is having the Pandora Papers in Netherlands? How is the discussion about it in this moment? Thank you very much.
Let's allow Donato to make this exception. Martin, Pandora paper, Josiane, any effect?
I don't know. I was on a holiday when they came out. But when you speak about journalism, I think it helps that we have some dedicated journalistic platforms following the kind of frauds that we and the kind of cases we prosecute and investigate, and that's growing. And you see that journalists work together across borders as well, and maybe that can inspire us as prosecutors as well to do that more often or more easily. But more specific, the Pandora Papers, I think they are still landing. And there was how you say that our Minister of Finance was named in it, and they're trying to form a government, and so this was not very pleasant news for him. But I don't know, Josine, what are your thoughts?
Well, as I'm now a national expert at Olaf, I don't know what if the prosecutor's office is doing anything with it. I do know that for example with the Panama Papers, I think they were evaluated and all the hooks for investigations were maybe not all of them because sometimes we have to choose as well, but they were taken very seriously, and I know that there were some investigations stemming from that. So I would expect the same. I can really also underline what Martin says about journalism in general. I did the international sanction violations for 6 years in the Netherlands before I went to Olaf, and I've had several times where there was stuff in the papers, or for example platforms like Bellingcat, before we were aware, and based on those articles or their information, we started investigations. So they keep us sharp. They have a very important role. I do find that sometimes the quality in the Netherlands could sometimes be a bit better if I look at like different international newspapers, for example. Less people's opinion, more really background information, but we have some platforms that do really well.
Thank you very much, and I will say that with these words we will finish this workshop. Thank you so much. Thank you, Lorenzo, for moderating the first session. Thank you, all the national experts and the project expert. It was a fascinating discussion, and I will let you know when this will be edited and published. So thank you very much. I will stop now the recording.